Okay, welcome. We are continuing our exploration of court procedure and evidence here at Wake Tech for the spring 2023 semester. And we are up to Chapter 6 of Criminal Procedure, 10th edition, by Joel Shamera. Cengage Learning is the publisher there. So we're going to be moving from the arrests. We were talking a lot about some of the Terry stops as well previously, and now we're really going to be starting to look at search warrants, which are an interesting field. I think they dovetail very nicely with the last couple chapters, and we'll see where we go here. But let's start off with talking about how vital they are. Crime control, it could not survive without the right to search. It's kind of like you can't run an organization, you can't run a society, you can't run a family, you can't run anything unless you have a mechanism to check to see what is and isn't true. And that's what a search does. A search says, okay, I think you've got marijuana. I'm going to search that area. Oh, there's no marijuana there. The search proved that you were innocent. Or I found the marijuana and that proved it was. So search is really very vital to establishing proof, and proof is, the foundation of the criminal justice system. So the Fourth Amendment balances the need for these searches against our right of privacy. And this goes back to what we talked about in some previous chapters. The idea that you give up a little bit of freedom in order to get a little bit of security. But you don't want to give up too much freedom, because then you're living in a terrible society. At the same time, you don't want to have so much freedom that there's no order, complete anarchy. So the right against unreasonable search and seizures is very difficult to protect, because there's always this tendency to say, well, just give me a little bit more authority to do this, give me a little bit more. And searches done for evidence include those done, and we're going to look at the different categories in here, searches that are done with warrants and searches that are done without warrants. Now, the Fourth Amendment does not condemn all searches. It only condemns, or bans essentially, those searches that are unreasonable under the Constitution. So what we're going to have to do is look at a number of these Supreme Court cases and really try to find where the Supreme Court draws this line. All right. So when we're really doing this, we're going to be analyzing these searches. We're going to be asking a question. First of all, is this truly a search? Of course, there's actually a precursor behind this. This is a governmental search. Because if I am the parent in a house and I search my child's room, that room isn't subject to Fourth Amendment protections, because it's not the government doing the search. If you're a spouse and you search your husband's wallet or your wife's purse, that's not a governmental search. Now, these can have civil consequences, certainly. Your employer might read your emails or search your desk. That might be an invasion of your privacy. You might have a civil action against your employer, but it's not a criminal event. So really the first thing is to bear in mind is we're talking about when the government does these searches. And most of the time the agent of the government doing this search is going to be the police. So we asked the first question, was it a government action? Was it a search? Is the search reasonable? And then if we reach the conclusion, yes, it was a governmental search, and yes, the search was unreasonable, then what should we do with the evidence? Should we exclude it, or should we admit it? Is there some reason why, yeah, it was a problem with the search, but we're going to let it in? Okay, so searches with warrants. We're going to at first break this down into a binary state, a search with a warrant and a search without a warrant. So Fourth Amendment commands that officers go get search warrants. Now, the problem with this is most searches are not done with search warrants. Even though the Constitution says, you're going to have a warrant to have a search, that's not been interpreted as an absolute. So it's been read into. Most searches instant to arrest, consent searches, these are done without warrants. So we're already in a kind of a smaller subcategory what we want. So let's talk about, if we are applying for warrant, what do we need? Well, we talk about particularity. And we're going to have another slide on this in a minute. It's a little bit more, and we'll go into it in some more detail. But basically, you're going to tell me where you're searching and what you're searching for. The second important requirement of the warrant is it is sworn to. It has an attached affidavit. You've shown the evidence, and you tell me why it's going to be there. And this is important, and I'm not going to spend a lot of time on it, but this is important because, of course, first of all, it means that there is a penalty of perjury if you lie. We are having an ex parte proceeding. We only have one person there. That's the state. The police are showing up and they're saying, give me this warrant. So we want to make darn sure that the police aren't lying. So we're going to say, well, if I'm the judge and I'm going to give you this warrant, you better swear that you're telling me the truth. And the third requirement is, and the courts are going to wrestle with this, is there is a knock and announce. We do not live in a totalitarian or police state, and it's a requirement when you're executing a warrant that you show up and say, I'm a police officer, please let me in, I have a search warrant. Certainly if you're talking about a nonviolent crime like tax evasion or something like that, you don't want the police to break down someone's door at 2 a.m. without announcing themselves with guns drawn. So let's look at that first one a little bit more. That's the particularity. All right, so first of all, you should think of particularity as a location and an item. Think of them both. So you've got an aerial view there of classic suburbia, so all the little houses all in a row. If you're going to conduct a search of an area, let's suppose you are looking for, let's just suppose you want to conduct a search. You go to the magistrate and you say, I want to search 404 Blake Road. That's the first part of particularity that the courts are going to address. So the court will say, okay, you want to search 404 Blake Road. What are you looking for, officer? And the officer then is going to, as the second part of particularity, say, I'm looking for X, Y, or Z. Maybe I'm looking for guns. Maybe I'm looking for drugs. Maybe I'm looking for the fruits of a bank robbery, the cash. Maybe I'm looking for evidence of tax evasion. Okay, maybe I want to access the computer there. So first you tell me where you're going to search, then you tell me what you're going to search for, and that's particularity. That has to be present in the warrant. If the warrant says any place for anything, that in the bad old days, and by bad old days I mean the American Revolution, was called a blank warrant. English magistrates would sometimes just, when mainly the army that wanted to do this, conduct a search, they would simply say, here's a blank warrant, fill it out and search. So the Constitution puts a stop to that. Now that probable cause affidavit, just like an arrest warrant, if you're having a search warrant, you've got to swear and sign it, the affidavit, the pledge, that this is where I'm likely to find it and this is what I'm looking for. This goes to that judge, and it's got to be a neutral judicial magistrate. I think it was an old Vermont case, if I'm not mistaken, where you could apply to a warrant for the Attorney General of the state, which is basically the prosecutor. So you go before a neutral judicial magistrate who should be, in his mind, balancing freedom versus security and saying, okay, what have you got? This is sufficient. Now, almost all the time, by the time the police go in a file for a search warrant, they're going to have enough evidence, at least in the eyes of the law. Are they going to find something every time? Absolutely not. Okay, search warrants in the digital age. We do have a bit of a problem in that increasingly a lot of evidence is not physical, but is information. So we just had the election of 2022. The Republicans have won a majority in the House of Representatives, and I was watching the news last night, and one of the things they said is, we are going to do an investigation of Hunter Biden's laptop. And I got curious, and I did some digging information about this laptop. Well, here's the thing. This fits nicely in our analysis here because it's not really the laptop you want. It's not the physical object. Okay? It's not the Dell or the Lenovo computer. What you want is the information inside the laptop. You want emails. You want records of emails. You want files that are kept in there. This is digital information. So there can be a problem in something like this when you go to a magistrate and say, I want to get this information. And now let's suppose that the information of Hunter Biden's laptop, which one of the fascinating things is, supposedly the laptop was cloned, and we have copies of the laptop in private hands. The laptop itself is in public hands, as I understand it. It's in the FBI's hands. But all we have is copies of copies that are out there. So, one of the questions would be, is this a good copy? And I think this is going to be fascinating for us here in court procedure and evidence as this goes on in the next few months, because it's going to occupy a lot of the news, I'm going to assure you. It's going to be very fruitful and interesting for us to do this analysis. Okay, so you go to a magistrate and you say, I want a copy of a copy. Well, does the magistrate know that? I want a copy that exists in the cloud. Well, maybe I'm an old timer and I don't know what the cloud is. Let's suppose I say, I want emails. Well, we all know what an email is. I want text. You know what text is. I want the copy of the text that exists here. Well, what's different than that or this? So, in other words, what I'm trying to tell you is that searches in the digital age get very complex. And it's often very difficult to establish where things are, and it can take a long time, and it can be, really, really impactful. Okay, so let's talk about that third requirement there, that no-knock warrant. Now, what's a no-knock warrant? Basically, it says to the police, you can go to this person's house or this business or this location, and you can enter it without announcing you're the police, and you can search it without announcing you're the police. And the question is, why can you do this? Okay, well, the courts have said this is an exception to the general rule. The general rule is you have to knock. Hi, I'm the police. Here I'm to search. Still, I guess I was kind of picking on Biden there. Let me pick on Trump a little bit. When the police went to Mar-a-Lago, the FBI went to Mar-a-Lago because Donald Trump was suspected of retaining records that he was not lawfully allowed to keep. National Archives has the right to preserve all presidential documents. They go to Mar-a-Lago and they don't do a no-knock. They're not worried that Donald Trump is going to run down from his bedroom at Mar-a-Lago and start shredding documents. So what do? They knock on the door and say, Mr. Trump, here is our subpoena. We are coming to look for these documents. And they found some. We'll see how important that becomes. So why would you have a no-knock warrant? Well, one of the first things is sometimes evidence gets destroyed. Now, we're going to look at a case in a minute where someone's trying to destroy some evidence we're looking for. But, classically, you knock on someone's house, you say you're the police. That person says, oh my God, the police are here, and they're flushing stuff down the toilet. It might be marijuana, it might be amphetamines, it might be illegal liquor. I don't care what it is. You're trying to destroy the object of the search before the police can get in and get it. So that would be one reason why you would allow this. The second reason is it might, by knocking and announcing, place the police in great danger, or an innocent party in great danger. So let's suppose that you're going to conduct a search of an individual's home who is suspected of a very violent murder and is known to be armed, and that has stated publicly that they'll never take me alive. Well, at this point, you might say, if I knock on the door and say, "Hi, I'm the police, I'm here to arrest you," that's putting a target on the police. So you might say, "Go ahead, knock down the door and search." Now, of course, the problem is, you know, when is the danger high enough to warrant a no-knock warrant? But when is it so low that you can't get one? Now, the third rationale, of course, is to prevent the escape of the suspect, and that's more an arrest warrant, but certainly, it could be something we're concerned of. So let's look at one of these cases, and this case is Wilson versus Arkansas. So this case came down in 1995. I think the initial search, if I'm not mistaken, was 93 or 92. But Miss Wilson, Charlene Wilson, had sold some marijuana and methamphetamines to an undercover police informant, and she's home with I think Joanne Potts, I think is the name. She's home with Potts, and oh wait, no, excuse me, I'm sorry. She made sales to Potts. Potts was the name of it, and she's home with a man named Brian Jacobs, who's the, I assuming, common law husband. And in 1992, the police, knowing that there's marijuana there, they basically apply for a warrant for a search. And at the search, they're going to arrest both Charlene Wilson and Jacobs. Now, the analysis, and we shouldn't worry too much about these individual facts, because the analysis is when the police showed up, do you have to announce yourself? And the Supreme Court actually engaged in a little bit of deep historical legal analysis, and this case was written by Justice Thomas for a majority. And this goes back to things like the castle doctrine, which essentially in North Carolina says a man's home is his castle. You have extra rights inside your home. The right to use force, for example, inside the home. So basically what Thomas says is the Supreme Court ruled that it is now a requirement in America, subject to certain factors like dangers of the police officers, that you must knock and announce. Now, okay, they're going to have to set up rules. What are the exceptions we're going to recognize? And I think obviously potential violence is perhaps the biggest one to look at. But certainly one of the fascinating cases that comes back shortly after this is Young versus City of Radcliffe. And that's going to be the next case we take a quick look at. So in this one, the police got the wrong tag from a shoplifting and went to Young's house. So basically, what the police were doing is they went and they got an arrest warrant, but not a search warrant. Now, the interesting thing is it's the wrong information, okay? Young was not at the Walmart, nor in any way involved with the shoplifting. However, his tag, and we're talking about the license tag that he had in his car, was wrong. So they go and they bang on his door, and they see his police vehicle there. They stand outside. Young is armed. He's very hard of hearing. He sees two cops in his backyard. The police see him. They shout, "Drop the gun." He didn't, and he shot. So the police said they were doing what they called a knock and talk. Without a warrant, they went to the house to try to talk to the suspect. The court, in its analysis, said, well, you know what? You weren't technically in the house, but you were in something called the curtilage. Now, the curtilage is the area that immediately surrounds the property. And by the way, to clear out that shooting in the backyard, when he saw the two cops, he claimed he couldn't identify they were police officers because they hadn't announced themselves yet. He didn't know who it was. So the court said when the two officers from the back were looking into the home, they were doing so from the curtilage, which is the area immediately surrounding the home and is under the law considered part of the home. And they said Young at this point had an expectation of privacy. And since they were inside the home, they better have had a warrant. And when they didn't, they could not cross that threshold without the warrant. Which leaves us to searches without warrants. So while securing a warrant before the search is preferable, most of the time it's better to go get a warrant. Most searches, as I said, are done without warrants. And courts have really created so many exceptions to saying that, yeah, there should be a warrant, but you don't need it in this or this case. It looks a lot like hearsay. Hearsay, remember, is warrantless searches or an out-of-court statement being offered for the proof of the matter asserted, but is deemed to be admissible because there's just one or more of these exceptions. Now, what are the major exceptions that the court will recognize? Here are 5 important ones. And I would say these are clearly the 5 ones. Searches made incident to arrest, we'll talk about that. A consent search, a vehicle search, a container search, and emergency searches, sometimes called exigent circumstances. So we're not going to take these directly in order, but we're going to look at them. Let's look at searches incident to arrest first. If you arrest someone, you can conduct a search before the arrest is complete. You can conduct it during the arrest, and you can conduct it after the arrest, and you don't need a warrant or probable cause for the search. You need it for the arrest, but not for the search. And what the courts have said is you can search those areas immediately under your control, what's sometimes called the grabbable area. And the search should be done contemporaneously with the arrest at the same time. So where did this come from? Well, we've got one of the most important legal cases, certainly in this chapter, the most important legal case is Shamil versus California. So the police go and get a warrant for Shamil. Now, he is being charged with robbing a coin store. So they go to his house. His wife is there as well with an arrest warrant, but they don't have a search warrant. And his wife lets them in. He shows up, lets the police in. He shows up. They arrest Shamil, and they say, can we search? And they said, we have the right to search. They tell him this on the basis of a lawful arrest, which that's how they were interpreting the law. So they then directed, he's handcuffed, and with the wife, they go around and they search the house. They search drawers and the workshop and the garage. And they find a lot of evidence that indeed he was engaged in the robbery. So he goes to trial and objects that this is unconstitutional. That you had the arrest warrant, maybe you can search a grabbable area, but you can't search the whole house. And the court did an analysis of this. This is in 1965, and Stewart wrote the majority opinion, and he said, the Supreme Court of the United States, interpreting the Constitution, does not ban warrantless searches, but it bans unreasonable searches. Here the police had probable cause to go get a warrant, but they didn't bother. So they had an arrest warrant, and that arrest warrant gave them the right to search, but only within a reasonable area. Outside of that reasonable area, what they called the grabbable area, such searches were illegal. Now, one of the things that this case kind of triggered is what we call the rise of the pretext arrest search. So, the big case here is what's called New York versus Benton. And we're not going to go through the individual facts of the case, but basically, the Supreme Court, in doing the analysis, permitted the searches of cars when a suspect is outside the car and under arrest, even if I'm just stopping them for the purpose of the search. I'm not really interested that they were speeding. I'm not really interested they made a bad turn. I'm much more interested that I want to search their car. So it's a pretext. And this gave the police a very powerful tool to stop people for minor offenses and search them. So how did this all play out? Well, after New York versus Benton, for traffic stops, after the police make a lawful custodial arrest of any occupant, they can search the passenger compartment, and that included containers. But this raised an interesting question that's going to be addressed about 10 or 20 years after this. But if the search is done after the arrest is removed from the car, the arrestee, the suspect's out of the car, how is any search inside the car grabbable? It was in the past, but it's not in the current. So there was a very large study done, that essentially said a guy named Myron Moskowitz did research that the methods, and he primarily focused on California, but he went through all these agencies and said, what are you really doing here? Are they really grabbable? Do you remove them? Oh yeah, we always remove them. If you're going to arrest them? Yeah, oh yeah, they're out of the car already. Well, it ceased to be grabbable. So this kind of came to a head in this next case, and this next case is Arizona versus Grant. This is an interesting case. First of all, in the way that human beings behave. Mr. Grant is going to be arrested and convicted of possession of drugs for sale and possession of drugs paraphernalia. But basically, Grant lives at a residence, and they thought that this residence was being used to sell drugs. So the police show up. He's not there. They come back. They conduct a record search, figure out that the guy they initially talked to was really Grant. There's some question about whether he was or wasn't. And they go back to the house. Now, Grant's not there. They find a man in the back of the house and another one in front of it. And a third officer arrives, and they arrest the man for providing false information. And you've got the initial two people are handcuffed, and they're sitting there. So let's just wipe them off the board. At this point, Grant pulls up in his squad car. Now, there's police there, and this is why I find this fascinating, is, I don't commit serious crimes. But if I saw a whole bunch of squad cars outside of my house and I was committing serious crimes like Mr. Grant was, he was selling illegal drugs, I don't think I'd pull up at that point. But he does. He pulls up in his car. He gets out of his car. I believe if I'm not mistaken, he shuts the door. And he's about 30 feet away from the car. And I think the car might have been locked, but I'm not positive. And he's out of the car 30 feet. They arrest him. Then they go to his car. They search the car, and they find drugs. And the Supreme Court at this point says, you guys have had 30 years, and you're using these protectual stops really that are violating the Constitution, so we're going to put some limits on you. You now can conduct a search if evidence only to those areas that are immediately under their control, not once he's out of the car for any length of time. So Arizona v. Grant limits the rights of these stops. And I think it's pretty important. So let's take a look at some of the reasons why we're going to allow these searches incident to arrest, and then we'll come back to some more rules about how the Supreme Court kind of changed things for stops. Why do we let them conduct a search incident to arrest? Well, protect the officer, prevent escape, preserve evidence. Okay, those are our three rationales. Now let's look at how that plays out in something called the Robinson Rule, which is when you're going to stop someone for committing a crime while they're driving their car. And the Robinson Rule is a blight line rule, and it says officers are permitted to search anyone they can take into custody because there's a possible danger to the police when you take them into custody. And it's really something we're going to leave up to the police because it's impossible for the court to review every single police decision. Now, one of the questions became, we're going back to automobiles here a little bit, is what happens when it's not an arrest, but it's a citation situation. So these are searches incident to citations. So sometimes a crime is not going to be classified as a felony, as a misdemeanor, but a citation. Citations are typically punishable only by fines. The question becomes, can the police conduct searches for minor stops? And the court didn't address this till 1998. And the case is Knowles versus Iowa. So Mr. Knowles is driving 43 in a 25. And at this point, as I understand Iowa law, they technically could have arrested him, but they didn't. They wrote out a citation. But they got him out of the car, and then they searched the car. So the police conducted a full search. They find some marijuana and a pot pipe underneath the driver's seat. Is the search constitutional? The court rules no. They said, look, this is much, much more like a Terry stop, which needs to be very brief and non-intrusive. There's a very low risk to the officer in these situations. I'm not so sure that's true, but okay. And there's no risk the evidence will be destroyed, because the evidence you should be searching for is not the marijuana, not this extra evidence, right? It shouldn't be pretext, but you're searching for evidence that he was speeding. Well, you've already got all the evidence he was speeding. You're not going to find anything else. So there's no risk that evidence will be destroyed, because the only evidence that relates to the stop, not what you're going to find in the search. So we have searches incident to pretext arrest. If an officer has a hunch they can find evidence of a crime, so long as they have probable cause to arrest, even for a minor violation, the arrest is valid, as in a search incident to pretextual arrest. But if it's not an arrestable offense, your search rights are very limited. All right, consent searches. This is another huge area in which we have a lot of searches without warrants. Consent searches are those in which you go to a person as a police officer and you say, can I search your bag? Can I search your car? Can I search your home? Okay? So people give permission to their officers to search their belongings, themselves, without warrant, and, I think critically, without probable cause. Remember, if I have probable cause, I don't need their consent. If I have probable cause to conduct a search, I don't need the consent of the individual. Right? But here, I don't have that probable cause. So the courts allow consensual searches, but they really want these consensual searches to be voluntary. Because we get very worried when the police kind of start behaving as if, as being bullies. And we don't want to create a police state. So we have a test, the voluntariness test, the totality of circumstances. What's your general knowledge that you have? And this could relate to education or age, and that's further on the scale there. What knowledge do you have of your right to refuse consent? Did the police tell you you can't refuse? Well, that changes the equation. How old are you? How mature are you? Can you make an independent decision? What's your level of intelligence? What's your level of education? Also, what's your level of exposure to the criminal justice system? Do you know what your constitutional rights are? Cooperation with an officer. Attitudes towards the likelihood the officers will discover contraband. What's the length of detention? The nature of questioning? What's the nature of the coercive behavior of the police? So we're going to have to look at a lot of things to really determine if something is consensual. And there can be, lots of cases here about these searches. So, the scope of consent, which is the next real big thing we're going to talk about, when the police have no probable cause and ask to search, I can tell you how much you can search. So, if you say yes, search, that's very broad. We're going to interpret that in favor of the police. But if I say, hey, can I search your bag? And I say, well, you can search this bag, but you can't search that one. That's okay. I can limit my search because you don't have probable cause for the search. If I say, well, you can pat my wife and I down, but you can't touch my child. The Supreme Court allows broad searches, but you can narrow them. And some searches can be quite intrusive physically. And if you're asked directly, you may not have warranted consent to these searches. The other thing the Supreme Court has said is you can withdraw your consent. The Supreme Court has never ruled if someone is voluntarily consented can withdraw, but lower courts have. And everybody agrees. Now, I say they never ruled about it, but I do think it's pretty clear. It's clear that any such withdrawal must be supported by unambiguous acts and unequivocal statements. Hey, stop searching, you're done, I withdraw my consent. And you can't say no backsies if you're the police. Okay, you're there. So let's look at a case. This case is a little bit further down, but it's U.S. versus Rodney. Okay, so Rodney gets off a bus from New York City to Washington, D.C. And without probable cause, they go up to him and they say, hey, can we search you? And they pat him down, and they really they were pretty thorough. Basically, he thought he was going to get just a pat down, and what they did was a groin search. They really grabbed and they found some drugs there. So Rodney claimed that the search exceeded what was reasonable. He said, my consent to a search was a reasonable consent. I didn't tell them they could do a body cavity search. I didn't think they would do a groin search. I thought it was a pat down. The majority decided that a body search can include groin searches, and the police don't need specific permission. Now, you can obviously see how in different scenarios this could play out in different ways. Can I reach in? Can I I just kind of jokingly said, can I do a body cavity search? But, that would be a question. Could I say, okay, can I conduct a body search of you? And you're thinking, well, body search means a pat down. And you say, okay. And they say, great. And they pull down your pants and they do a body cavity search. Well, you might say, well, that's too much, right? If you were shocked and you didn't say, wait, stop, would it be okay? All right. Now, we do have sometimes an issue of third-party consent. There's both a subjective and objective rule here to decide whether one person can consent. You can have actual authority and you can have apparent authority to search. And this can result in some different results. But basically, actual authority, and the actual authority was it's a 1964 case when it was adopted. When someone has, in fact, the legal authority to consent to a search, any consent to the search of the home is enough. The actual authority to consent, and it's actually a case, the case was Stoner versus California. And someone who has legally and specifically authorized can consent for someone else. So this could be a husband consenting for a wife to search a house. There's actually a North Carolina case. I think the case is called Bumper versus North Carolina, who has consenting interest. And in this case, the Supreme Court found the police had coerced. Here's a North Carolina name for you: Hattie Leith, to consent to the search of her house where her grandson was living. And they found a rifle, and they admitted it as part of a rape and a felonious assault. And Bumper conceded it had been voluntary. It would be binding on him, but the Supreme Court agreed that she owned the house and then therefore the rifle. Okay, so let's move on from that. You have then the apparent authority cases where we look at it. Where a law enforcement officer reasonably believes someone has the consent, but they in fact don't. And really, we have we have some fights about this, and the big fight is can we well, let me drop back and talk about Illinois versus Rodriguez. I didn't necessarily outline that case, but let me look at it. So in this case, Mr. Rodriguez was charged with possession of a controlled substance with intent to deliver. So it's a pretty serious crime. Um, what happens is the police are summoned to the residence of a Miss Jackson, and they're met with Miss Jackson's daughter, who looked like she had been beaten up. So she told the officers, "I was beat up by Mr. Rodriguez earlier in the day in an apartment over in Southern California," which I forget. But basically, and that Rodriguez was still asleep there. So she said, "Well, I'll go with you there, and I'll unlock the door with her key, and you can enter and arrest him." And whenever she talked about this apartment, she called it ours, 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 and it was a little unclear whether she said she lived there, but she used the possessive pronoun. So they drive over there. She unlocks the door with the key. She says, "Go ahead in." They go into the door. They see drugs and paraphernalia, white powder, which turns out to be cocaine. They go to the bedroom. There's Rodriguez asleep. There's more white powder with him, so he's charged with possession of a controlled substance with intent to deliver. And they start to do an analysis, and they find out in the Rodriguez case that she doesn't live there, but she is an infrequent visitor in the apartment. Her name's not on the lease. She didn't contribute to the rent. She wasn't allowed to invite others to the apartment, and she did not have access to it when he was away. But she had moved a few things in. So, the question becomes, was the search okay? In the present case, in this case, the Supreme Court. I gotta pause it. Okay, sorry about that brief interruption there. But to return to this case, so the initial analysis, is done by Scalia, joined by Rehnquist, White, Blackmun, O'Connor, and Kennedy, I believe. But Scalia, who tends to be very pro-law enforcement, says the police don't have to be right. Okay. What he actually says is it doesn't have to be perfect, but it has to be reasonable. Reasonable is what he talks about. In fact, what he says is the government doesn't have to be factually correct, just reasonable in their search. And if you have apparent authority that is reasonable, then the search is okay. Now, there was a dissent. The dissent was written by Marshall, Brennan, and Stevens, but there was only 3, so it was 6-1 there, and that was that. Okay, let's go to the next one. Let's talk a little bit about vehicle searches. Vehicles are an exception to the warrant requirement. We allow warrantless searches of vehicles if there is probable cause to believe that contraband or evidence exists. And why is this? Well, first and foremost, because there is a lower expectation of privacy, then because vehicles are mobile, and finally, there can be persons and containers within a vehicle that may be subject to search. So, searches of automobile passengers. Again, the passengers have a lower expectation of privacy. Passenger containers can be searched even without probable cause due to the reduced expectation of privacy that we see inside automobiles. So overall, if we start to look at these cases, searches of the cars expanded during Prohibition. This goes to Prohibition being the banning of alcohol. There was a lot of alcohol transportation that was going on there. Bootleggers were smuggling booze in cars, which are very mobile. In 1925, we have U.S. versus Carroll versus United States, saying passenger compartments can be served, glove compartments can be searched, trunks can be searched. So it's very broad in the 1925. And remember, we have a very, very conservative court in the 1920s. I mean, you're coming off of the Hughes court, and you've got you know, a very strong law and order court in that regard. About your containers and passengers, like I said early on, because of the Warrant prohibition, these searches were expanded. And this is kind of continued. We see in California versus Asidio, 1991, we allow searches of containers and trunks. And in Wyoming versus Houghton, in 1999, we allow searches of passengers too. So it's very, very broad. All right, let's look at another one of these big exceptions, these emergency searches, which is sometimes called exigent circumstances. So some situations make it impractical, even very dangerous, to go get a warrant before you do the search. So what are some of these dangers? One, the big one is the officer's safety. And this can be very important. I have a family member who was a police officer who was killed in line of duty, and he was killed during a traffic stop. So it is not uncommon that police officers are placed at great danger. So you certainly would want them to be able to conduct certain searches. You also have the danger that evidence could be destroyed. You have the danger that the felon might flee from the area, and that people in the community can be placed in immediate physical danger. So the destruction of evidence, warrantless searches can be permissible if you've got probable cause. So these warrantless searches here, there's better have been evidence of, yeah, you could have, if you had time, go get your warrant, but you didn't because this is an emergency. So warrantless searches are permissible if the police have probable cause and they believe evidence is about to be destroyed. The other big one, besides danger, we got one more after this, is hot pursuit. If an officer is in hot pursuit of a suspect whom they have probable cause to arrest, they can follow him into a house without getting a warrant. Be careful if you're a police officer. I say be careful because in North Carolina in particular, the courts are very hesitant to embrace entry into homes, but we do have several cases. The big case is United States versus Santana, came down in 76, I believe. You don't need, and if you have a robbery suspect who ran into a home, you don't need to go get a search warrant. But how extensive can a search be after you go in? You can't certainly search every nook and cranny if it's a hot pursuit, and there's a couple cases of it. Nor can you look at every room in a hotel just because a robber went into the hotel. Final slide, final point here is danger to the community. Some warrantless searches are going to be permitted if the officers have probable cause to believe the suspect has committed a violent crime and that they or others in the community are in immediate danger. So if you reasonably believe someone had bombs, and that case is U.S. versus Lindsay, if you saw a dead body on the front porch, that was an interesting case that came down in 85, I believe it was U.S. versus Doe. So dangers can be fires, explosives. So if police officers show up at the scene of a fire, they don't need a warrant to go inside a building, looking for injured victims or to investigate the crime. Now, after the fire is over, we can have a different story. But that you can't enter simply because there might be some danger in the offing. For example, and this is the case, United States versus Wagner came down in 88, said it wasn't reasonable to enter a house where they knew a man had kept dangerous chemicals for 2 weeks but wasn't home at the time. Well, that wasn't enough. So when we're looking at these dangerous community, we are looking at a sort of immediacy. All right. Again, that's right around 45 to 50 minutes to an hour. That's where I'd like to keep it. Whenever you're ready, you can move on to Chapter 7, which is our special needs searches. And I will talk to you then. Have a good afternoon, morning, or evening.